Great. Good afternoon, and thanks for that great introduction by Carlo, which sets the scene for what I would like to talk about, which is one of the key aspects of this Plugfest, which is interoperability, basically, and how to ensure interoperability in a world where we have this legal framework, which is sometimes actually contradictory and by default applies restrictions, which in many cases impede or prevent what the engineers, what most people are trying to achieve. My title is Openness through Interoperability and Open Standards, and maybe that's because with my free software hat on, I think of openness as a goal, as something to achieve, because it has so many positive side effects. But probably the talk should better be said as interoperability as the goal to be achieved through different ways of openness. Because in fact, from a technical point of view, what this conference is about is on interoperability between different types of platforms, different types of systems, and even different business models. So taking everything that Carlos has said quite carefully, because in fact it's a little bit of a minefield, in that there is a disjunctive between engineer or the engineering side, which basically usually do what they can do, and the lawyers who say what they may do. And that creates a certain tension that the technology goes much faster than the legal regime. The regime does not catch up with what the actual the technology requires. And the basic tenet of any engineer is if you have a problem, we solve it, and we don't really care how we solve it, so long as it's efficient or more and more efficient in a way. And that can actually come across all sorts of problems. And as Carlos was saying, one way of solving the questions of interoperability is ensuring that everybody speaks the same language, understands the same formats, the same parameters, and therefore they standardize, whether it's a de facto or a de jure, a formal standard. That is one of the ways of getting out of this minefield. Of course, the problem is, especially when you're talking about free and open source software where things sometimes are chaotic, but even in large corporations where there are large, significant numbers of engineers and working on technology, what they don't want to do is end up like this poor fellow here who just gets caught up in reams and reams of paperwork, probably all the fault of the lawyers. So we have to say our mea culpa in that one. So what I was trying to explain on the basis of Carlos' talk exactly what the tension is between these restrictive laws, which can cause problems on the use of certain technologies, and how there are different ways of trying to solve this to achieve this goal of interoperability and openness towards different business models, different technologies, and different platforms. Okay? Interoperability, as our friends at Wikipedia mention, is the property that of a system where the interfaces are known, are completely understood. And when we talk about completely understood, this concept of secret is obviously very underlies this. To work with other products and systems. So here we have a process. A process is something that is patentable. So here we have the problems of patents, and the present and the future. And without any restricted access or implementation. Restricted access implementation, we're talking about copyright, maybe restrictions, licensing terms, particularly contractual or standardized licensing terms, and other forms of restrictions which we've already seen. Okay, I won't go into this. The engineers are much more up to date. You guys are probably not much more know about this than I do. What I do want to mention here is that if interoperability is our goal, we want to achieve this interoperability, then it is the goal of what we've been talking about. If we talked about the keynotes, we heard both Julian from Zential, we heard the guys from Microsoft saying interoperability is a key factor. It's a key factor of success, if not the only factor of success going forward in any on-premise or even cloud environments. But also, actually, we notice from a legal point of view that interoperability is a requirement. This is specifically in public procurement contracts, where, for example, within the European interoperability framework, both numbers 1 and number 2, the fact that the software that is delivered to the public entity has to be interoperable with existing systems that they already have implemented is a contractual and legal requirement. And also at national level, the Spanish law for 2010 establishes the Spanish interoperability framework, and whereby they are specifying both standards and means for interoperability as a requirement. So it's not just something that is good in technical terms, but something that actually, for creating the infrastructure for the information society, at least from the government point of view, it is something that is a legal requirement. And that's very important. And I think the focus of my talk today is the two ways we're looking at these days to achieve this interoperability. And the first one is obviously very clear, which is free and open source software. And the other one is in standardization, because even if you have proprietary software or closed software where the source code is not actually revealed, you can at least have open interfaces that can expose the functionalities of those software and thus be interoperable. And that's where the standards come in, because that's where those or specifications come in, because that's how you specify how to talk with those things. Okay, open source, I don't need to go into much comment. I do like to insist that it is free and open source. It's not just open source. I think it's a very important point. And that's free as in freedom, not free as in the cost, although there are economic impacts. And that freedom actually is absolutely essential, because the freedom is what we need for interoperability. The freedom to use, adapt, and share, which the fourth is to adapt and share the adaptations, so that's the fourth. But those are the absolute essential freedoms that are granted by a free software license. And the specific one here actually is the use, because what a patent does is prevent the use of a certain process, methodology, or a product. And whereas copyright may restrict the copying or the distribution of a certain technology, what a patent does is actually prevent the use of it in whatever form it's implemented. So this is where a patent comes in, because if a patent is over a protocol, if there's a patent restricting, or someone has obtained a patent over a method of communication, a certain file format or whatever, then it has a monopoly right, an exclusive right to use, manufacture, import, export that any product based on that process. And that is where the essential freedom to use is actually something that is very, very important. What does that mean in terms of what we're talking about today in interoperability? Well, there is a de facto interoperability because you have access to the source code. So, of course, anybody can actually look at the code. And even if there's no specific API, if there's nothing actually descriptive, there's no specification or whatever, someone actually sit down and use the source code to create an interoperable program. There's a de jure or legal interoperability warranty by the fact that the licensing terms allows you to do that. It's not just that you have access to the source code, but the licensing term says you may do this in various ways. And so that's a very important thing. And what we're seeing is that even if the first generation of free and open source software licenses didn't really mention patents because there were not specifically so many software patents in the 1980s when the first licenses, the MIT, the BSD, or even the first GPL, though that was already thought of in those days. The more recent generations of licenses like GPL3, MPL2, and Mozilla, the new Mozilla license, they're very, very explicit about it. And what they say is that anybody who's contributing code under this license is also granting a patent license, not just a copyright license, but is also granting a patent license to any patents that they may hold over the software or the processes implemented by their contribution. This doesn't mean to say that it's patent-free, because there may be a third party out there who has patents over all this stuff, and as that person is not actually contributing, therefore there's no patent grant. But at least within the small community or larger growing community of users of that free software, there is a patent piece, there is a patent license to use and implement and install whatever the software and the processes managed by that software. Okay? And I think another thing which is really, really important, and is something that we've seen problems over the last 20 years, is that we have a forward-looking. It's a warranty to be able to use, to be interoperable over time and space. When I say over time, it's because the code's out there, the licenses are irrevocable and perpetual, so there is no restriction in terms of time as to being able to access technology and to understand that technology. And when I say space, it also means users, geographic scope, the user functionalities, whatever the usual use cases. So even in 100 years' time, well, 100 times outside, usually outside the scope of any form of legal protection, but even if there were perpetual rights, then the free and open source license, what it does is permit that type of exploitation of the technology, and thus interoperability with any other forms of systems, platforms, data formats, or whatever. Okay. The other way of trying to achieve this interoperability, where we have this underlying legal framework, which is restrictive, is the standardization process. And this we should probably split into two parts, because actually there's also the open specification process, which I think Microsoft, we've been talking about this with participants here at the conference, about actually specifying or providing openly the specification of the protocols and the APIs for accessing the technologies. And that's the first step. That's overcomes the barrier of secrecy. It doesn't necessarily deal with the issue of patents. It doesn't necessarily issue with the deal of licensing. But at least open specification is a first step. And it's obviously the most important from the engineer's point of view, because once you have that information, then you can actually work. The rest of it is all just lawyers' rubbish, which you have to send that to the lawyers and sort it out. The most important thing for the engineers to ensure this interoperability is the information, the basic information. And that's where open specification comes in, and that's a very important first point. But apart from the question of secrecy, it has nothing to do with IPR in terms of copyright, patents, and technically also competition issues. Even if you do actually reveal something, it doesn't mean to say that they're not competition obligations. Okay? There are various definitions of what a standard is, obviously. The key point I want to say here is that when you actually define a standard, what you are defining is a protocol or a product or a process. And that is exactly, if you look at patent law, that is exactly what patents cover. They cover products and processes. So it's there's a very clear mapping between what a patent can cover and what a standard is in many ways. Okay? So what type of standards do we have? Well, we have de facto proprietary standards. We have standards that are established by specific software vendors or technology vendors. And it's standard in the way that de facto in the fact that obviously those with a dominant position or a very significant market share and also with effective network effects, it becomes the standard. If it's not a formal standard issued by OSI or by ETSI or whatever, it's the standard way of dealing with something, a standard format, and therefore acquires the nature of a standard. And those ones often are those that are encumbered in the ways that Carlo has described, secrecy, IP, in different ways. And obviously, within the standard, what we are looking for is open standards, because this openness is what we're trying to achieve through for the goal of interoperability and creating mixed platforms. The question of open standards has been greatly debated. It is often mainly kicked up by the European Interoperability Framework, version 1, where there's a huge debate about open standards. And the question was whether the European Union and therefore the governments also of the member states could oblige software providers or technology providers to comply with certain standards, and those standards had to be open standards. Okay? So and they can have technical specifications, they can have user requirement specifications, and then amongst those other ones, they could have a specification that certain technology had to comply with a certain standard, and what type of standard that could be. Okay, so there's a big debate, and the normal way of looking at this is that there had to be an open process in the creation of the standard, and openness in actual use of the standard, which became very, very problematic, because many large corporations participating in the standardization process had patents or have patents over what they were submitting, proposing as to be the standard. And they were not so keen on either royalty-free or fair and reasonable non-discriminatory terms, or even just total openness, and as if it was a kind of like an free and open source software license over the patent. So basically, they had a patent, and they were just waiving their rights. They would have any rights to claim under that patent. So what happens there in the standardization process is that these are semi-official bodies. There are some which are private, some which are even have government entities participating. And they sit down, they talk, they throw up all sorts of ideas. They try to get together to create what is the best process, what is the best way of doing something. And they come up and they publish the standard. And in that process, most of them have this obligation that if a participant member makes a proposal for the standard, they must disclose any patent they may have over what they are contributing. So if someone's participating in some audiovisual new format, MPEG-5, coming up, whatever it is, the next one generation is MPEG-6, I think they're jumping numbers, aren't they? They would have to disclose if they have a certain patent over a file format, a compression format, or something like that. So that there's ex-ante disclosure requirements, which gets over this issue of secrecy, okay, in one way. But it doesn't deal with the issue of patents. It doesn't deal with the patents because even if they disclose the patents, they can still use those patents anti-competitively or at least against openness by forcing people to pay royalties to comply with certain obligations. And this is where the second level comes in that depending on the different organizations, they can impose on their members certain licensing obligations, of which the most ones are FRAND, which is free, fair, reasonable, and non-discriminatory terms, which means that you must have an obligation to offer a license to any user of that standard under those types of terms. This is a huge debate exactly what is fair, what is reasonable, and what is non-discriminatory. And there have been many court cases, and there have been many different criteria that come up, and I'm not going to go into the details. On the other end, there is royalty-free, which means that you get it for free, i.e. in free in monetary terms. But when you look at it, actually, a lot of the royalty-free licensing terms are not restriction-free, which is what we want. We want restriction-free. We don't want royalty-free. Well, we do want royalty-free. But we also want restriction-free, which means there are no additional obligations, like quid pro quo. I'm giving you FRAND terms or royalty RF terms on my license if you give me on your portfolio of patents. And that's obviously not possible for many people. And then there's FRAND 0, which means it's reasonable and non-discriminatory, but it's zero price, which means you're looking at these additional restrictions. Okay? Just briefly, this is 2012, I think. Haven't had time to update it, but I'm looking at some of the most important standards organizations here. EDC, IETF, OASIS, W3C, which is on the web. They have a variety of licensing obligation policies. FRAND, most of them, although W3C has a royalty-free and restriction-free policy, though Carlo said he was recently been looking at it and maybe has some doubts about it. Yeah? What are the problems with FRAND? Well, the main problem with FRAND is that we don't know what FRAND means. So that's very complicated for someone implementing a technology, which means it's open to negotiations. And we've seen there's quite a lot of court cases about exactly what these negotiations, when they should occur, how they should occur, and what information should be disclosed in these negotiations. And that makes it it's feasible for a large corporation. It's totally unfeasible for a small corporation, and it's totally impossible for a free software project. There's legal uncertainty, which for Carlo and me, it's great. It means we have lots of business. But for anybody else in the technical sector, it's bad news, because anything that causes friction in creating technology is not a good idea and is not desired. Okay? And especially for FOSS projects, for free and open source projects, it raises huge difficulties, because often there is no legal entity to enter into the licensing. The licensing terms are they may be usable by the person creating the software, but can you pass on those obligations or the benefit of that license downstream to all these many levels of users of your software? And this is one of the huge problems we have with copyleft. Copyleft, as you know, under several licenses, but specifically the GPL, has this obligation that if you redistribute the same work or an improvement on that work, you have to use the very same exact licensing terms. So if you've received a patent grant, and this is what happened with Novel had a patent grant from Microsoft in a certain case, you had to be able to pass on that patent grant and the benefits you had downstream. Well, there was doubt about it under GPL2, and when GPL3 was drafted, they made it very clear that anybody who was licensing under the GPL3 had to pass on patent grants, the benefit of those patent grants. And that's what we're seeing, a huge problem. If you have a FRAND license, even an RF license, over a standard that you're implementing, is that it's legally virtually impossible to pass that on in a way that's compatible with the GPL. And Red Hat had a great, I think, year and a half negotiating one of these to enable to have basically Red Hat obtained a single payment, paid for the patent license. It was a perpetual license that it could pass on downstream to anybody using that software in any circumstance. So that was a bit of an exception to these issues of relicensing these patent rights. So in practice, what happens? In practice, this is in my practice, and probably Carlo as well, and most free software lawyers I know, is that we're very, very wary of patents. We obviously were very careful when we give legal advice. So when a project comes to us or a company comes to us and say, "Look, can I implement this?" Well, look at what's been said. Look at the licensing terms. We always kind of look up if not a red flag, it's an orange flag, and that's really bad news for developing any technology. So what we're actually aiming at is for a green flag in every case, and the only way really to get a green flag is to not patent at all, as that's not happening. There are other ways of trying to get this green flag on certain protocols and processes. One is to be actually a contributor under the license, so the license terms kick in, and therefore all the patents that apply to that contribution are downstream by the actual license. Another one, obviously, is to make these certain forms of patent pledge. The trouble is that these patent pledges have to be worded really carefully, and not just to be some marketing blah blah, or even more than marketing blah blah, actually go to some of the details. You do have to take free and open source software licensing into account, and even GPL licensing, even more so, into account when you make this type of patent pledges. And that's not happening in many cases. So, and this just, on the slide here, we see the success stories, and where we see, patent-free technologies are actually doing better than patented technologies, which I think tells a story in itself. So that's basically what I wanted to kind of comment on. This is this tension between the underlying legal framework, which Carlo has been commented on, and the efforts that are made both on the open source and the more proprietary and open source communities to deal with the issues of open standards. We were now going to have a small talk. I have some questions for Carlo. You can't ask questions yet. We're being very dictatorial. You can ask questions afterwards. We've still got half an hour. Yeah, you can ask as well. But I've had a couple of questions, and he may have some for me. Do you have a microphone?
I do.
You do? Yeah, well, I can now sit down. Does it work?
No, not yet. We're making it work. There's some problem. Hello?
Yeah,
hello.
There you go.
Radio frequency.
Can I kick off with the first question then?
Yes,
I've been talking a lot.
I fear that. Yes.
No.
Should it?
I don't know how to deal with the feedback here. 10 years ago, we were always talking about software licensing, free software licensing. What's a free software license? What's copyleft? Today, in the last 5 talks I've been giving, it's always been about open standards and open formats. What's the cause of this change?
Because standards are getting more and more important. That's one question. Or because licensing is understood. That's a second answer. Or because, as we have learned, the free and open source way is getting so much traction that it's not a point of whether, but the point is how to do it. And the problem, and the other issue is that 20 years ago we didn't have software patents. We just discovered that software could be patented like 20 years ago. And now this is the real problem. I don't have an answer. Sorry to this question, but the very fact that we have no definition for open standard. Anytime you try to agree on what is an open standard, you are faced with strong resistance. The entire EIF history shows that. And we don't even have the opposite of open standard. What's the opposite? You said proprietary standard. Standards are not proprietary. In a way,
I was more talking about proprietary interface that becomes a de facto way of doing something.
Yeah, it's with the Euro standards, it's a part of a couple of examples I can think of. They are a cooperation between different people to get, and it's an open process. It's an open process, meaning that everybody is allowed to contribute. But barring few exceptions, everybody is allowed to participate and to contribute. But at the end of the day, the standard is formed by the usual suspects, which have sufficient money, time, expertise to contribute, and technology to contribute. And the output, the use of the standard is restricted because of the underlying patents on technology. So the very fact that everybody claims to be, every standard claims to be open, but very few are really open, and that we don't have the opposite of open standards, it shows that this is something which is still in its infancy, whereas with free software licensing we are much more mature. It's not an issue anymore. You go to fine details. With open standards, we are way back in history.
It's also the fact that, I mean, technology is going more and more to the cloud, as we were saying this morning, and therefore a lot of free and open source licensing is not so relevant in actually, because the code itself, the technology itself is not actually delivered or distributed to third parties. The copyleft, the great invention or revolution that was copyleft actually is not now such a strong force because of the cloud offering. And therefore, there's a reduction in the impact of licensing and a much greater impact of the interoperability.
Code is getting less and less importance because less and less code is distributed. And more code is used behind firewalls, literally firewalls. So yes, the lack of distribution of code means that copyright is not relevant, or not that relevant, and copyleft, of course, becomes less relevant. And there are attempts to use copyleft into the cloud, speaking of cloud, of course, there is a shortage of very well-defined and standardized ways to share services in order that a client of a cloud service is assured that my data are there, my services are with that service, but tomorrow I can bring them back. This is more on a voluntary basis. Of course, there's an OpenStack. There are many efforts to standardize that, but still untested. And there must be a strong effort in that direction.
It'd be interesting that in the 90s they used copyleft to force the openness to force in a way, and well, for people sharing a specific philosophy, but also to force the openness. It'd be interesting to find some kind of like cloud licensing terms to force the openness and interoperability of these services. We'd have to kind of like think of a way of doing that, which I can't really see. And not just the making available of the source code of the code, which is the Affero General Public License, which most cloud providers don't use because they don't actually want to be able to be obliged to reveal their source code, which is a way, because if they have the source code, you have the interoperability information.
It cannot be, there is no, a copyleft was a hack of a legal system, a hack of the copyright to achieve openness and freedom. With cloud, I think this is beyond reach. So with cloud, we need to raise awareness before it's too late, before people, entities, corporations, governments must be aware of what being a cloud means in terms of savings, efficiency, security, redundancy, whatever. But also it's a new game with new risks, with new benefits and new risks. And people must be aware, and then we must work to find a solution to the interoperability issue, which has different characteristics from interoperability in service that you run on your own services, and you just need the right software to plug in and to tap into.
Yes, I think data formats suddenly become much more relevant, in that because you do have at least in a cloud environment access to you should have access to your data. And those should not be in proprietary formats that prevent you reusing that data in other systems and other services. And that's something that I think vendors are starting to actually sell as a selling point, is that the formats they use for client data, client management data, or whatever, are open formats in the same way as a format can be a standard, and therefore it's something that enables the client to get out of that cloud or move the data into another cloud, or even just be elastic and extend into different types of clouds using other different provider services for redundancy or for whatever.
Okay. I'm asking you a question, but I perhaps know that
I tremble at the knees.
No. Perhaps I sort of know the answer, but still having somebody elaborating is more useful. So you said that an open standard should be a standard which can be implemented. Sort of. I don't want to put words in your mouth, but I think I can summarize. An open standard should be available also to make free and open software. Open source software distribution, so it should be compatible with things like GPL v2, v3, which have patent, explicit patent licensing downstream obligations. The question that my devil's advocate would have is, isn't it that a self-inflicted problem by those who say, we need to do these things this way, and this coincidentally is incompatible with a traditional FRAND licensing of patents?
Yes and no. I mean, very much in the fact that, I don't know if it's voluntarily, that's true. But yes, the fact, especially as these licenses are redrafted, I mean, with the 1991, the 2007 for the GPL, the MPL also, and they are certainly in the most recent generations, they're very aware of this issue. So it's self-inflicted and self-exclusionary, which means that we know these standards exist, we know these standards have patents over them, and these patents are going to last for another X years, up to 20 potentially, and therefore we know that we are not going to be able to implement. Let's say a video, audiovisual, media player, whatever, with certain formats, because it's impossible then to continue distributing downstream. But I think that's also a very political decision that was taken at the time. Yeah. I think it's self-defeating in terms of adoption, in terms of people taking up that technology and using it liberally, permissively. But I think it's also a political statement saying we disagree with patents and therefore we're going to make it very difficult. We don't want my software to be implementing patented formats, processes, protocols, because we disagree with it, and therefore we prefer to be in a world, even if it has less functionality or less utility, we prefer to maintain this freedom that we've been stating. So I think it's, yes, it is self-defeating, but I think it's, in take-up terms, but I think it's also satisfying the goals, especially the Free Software Foundation in this case, of maintaining this freedom. It's a bit like freedom at any cost. It's unfortunate in terms of worldwide adoption of those technologies, but I mean, maybe maybe in the long term they're right. Maybe that's the only way to go.
I think we should make differences between standards which are mainly implemented in software, with general telecommunication standards go into devices mainly rather than in software. And
with open hardware is going to become even more of an issue, because even hardware is even more easily patentable in a certain way. So the more we go down the open hardware role, where you have blueprints for building different machines, products, or whatever, then. We've been participating in different initiatives to draft open hardware licenses, and I still think that issue is not resolved yet. And that is also an issue of interoperability at the hardware level. Yeah. Is that?
Okay, we open the floor for questions. Is there any question from?
They're all asleep. We put them to sleep.
Yeah. Sorry.
They needed some coffee at the door.
So I was curious of what you have mentioned before, like we might have a solution to.
Well, I mean, it would be on a case-by-case basis.
I thought it was going to be the question.
Oh, yeah. So I guess I was saying, on a case-by-case basis, if it would depend a little bit what the goal of somebody is. In terms of you talked about in 2007, 2008 timeframe, we've heard downstairs that we've released all of our protocols and the documentation that we do and Plugfest testing and all these things we do to make sure it all interoperates. And then we have what's called the community promise and the open specifications promise that goes with those to ensure that people who just want to play with these things and develop and get something to a place where they could make a product out of it don't have to worry about us. But the other side of that is once you're ready to commercialize, there are concerns there. And you know, as one example, even if we weren't even aware of your situation, sometimes for government contracts, they require that you have the intellectual property rights to go with it. And so you would want to actually come and seek us out and make sure that you're clear. And I'm saying that we may have creative solutions to give people comfort in those spaces, even where a straight patent license isn't something that would work for both parties.
I beg to take exception to that position, because when you say on a case-by-case basis, this is per se contradictory to the whole idea of open source and free software. One of the basic tenets of free and open source software is that no restriction, no field of use restriction. So if I can do something that my fellow cannot do because I'm using this software for doing something and he's using the same software or part of this software to do other things, I have liberties that he's not benefiting from, and at least the entire concept of copyleft is to avoid this through maintaining that what I have, he has, and the reverse is true. So when you are discriminating on the basis of the commercialization of the software, you are putting boundaries to where the software can go, and that is directly against the licensing. The license, all the copyleft licenses forbid you from imposing restrictions. So there is no way I can comply with copyright and at the same time comply with the Open Specification Promise most of the time. So this is not a solution. So people cannot have the alternative of violating copyright or violating patents. So, or being an infringement of patents. So this is the solution the Open Specification Promise faces with free software. You want to chime in?
No, yeah, it also creates uncertainty, and that is particularly difficult for entities that don't have the resources for dealing with uncertainty. And this is many small, medium-sized or open source projects, or even small companies, SMBs. And that doesn't make it easy for them to take up the technologies, relying on that pledge. And again, then they suddenly turn to market and they find themselves with a new area where this technology can be used, whether it's under an open source license or even just normal licensing scheme.
Yeah, I'm not claiming
that causes another area of friction. I mean,
sorry. I'm not claiming that the Open Specification Promise or the developer pledge or whatever it's called are totally worthless. They have field of application where it can work. It doesn't work in a free and open source software regime. There are ways around, of course. Everybody must leave the real world. And so there are workable solutions which face uncertainty, but this is an imperfect world, and we cannot have it all perfect. But we cannot also claim that this is a solution. There's uncertainty, and all uncertainty should be removed as much as possible. And other patent pledges are more straightforward and doesn't pose any limitation to the commercialization. Red Hat was an example. They made a patent pledge. Sun has done the same thing. Yeah. There are ways where you can remove uncertainty and free the market from this lingering. There's this is in the power of the owner of the patent to do that. There's no need to preserve the patent. It's a decision to obtain a patent. It's a decision to retain it. It's a decision to enforce it or not enforce it. So. if you go that route, I think that many agree that in software, it's, I don't know what the exact phrase is, it's 100%, this is what Thomas Edison
Yes, it's a
it's
bit before software, but yeah.
It applies even more. With Edison, it applied to his invention because it was 99% other people's effort and 1% his effort. But it's, he said it's, in software it's 1% inspiration and 99% perspiration. So it's, in our experience, maybe it's not the same in all areas, but in software, strictly speaking, the way of doing things is the value is more in the delivery of the software than into inventing how software is done. So the patent protect this yeah. This is a general topic on why software patents shouldn't be allowed in the first place. But we're not only speaking about pure software patents. There are patents on technology who are halfway between software and hardware, and multimedia are part of that. Compression is also halfway. So we are investing into technology. It's a 20th century claim. Nowadays, it's more about interoperability, is standardization, which plays a big role in the advancement of technology. So, claiming that a proprietary utilization of the R&D doesn't quite make the cut, in my opinion. It's not in my opinion, of course. Maybe others have, but once you have are considering that interoperability is so important, everybody has to make a step back from I need to protect fully my intellectual property because otherwise I will be giving away. This is not, of course, open source. Free and open source software has shown this proprietary attitude is sort of a thing of the past. And this is true mainly with patents. Well, Microsoft has become very dominant without holding one patent until 2001. They didn't have virtual patents. They become almost dominant. So it's a good example for how an industry can be created, put into good use to earn a lot of money without having patents. So, of course, the question is always, should I waive my patents first? So why me? Why not him? Why not him? And this is a vicious way of reasoning. Yeah, everybody should, and this is a political position to hold, not one single company, of course.
But I mean, that's why the standardization organizations, certainly those that have the restriction-free policies, ensure that all the players are on the same level, the same level playing field. You know, if
absolutely.
So I think that and one of the huge successes of the W3C is exactly that. WC3 yep. is ensuring that the web technologies are not at least the standardized parts of the web technologies are not patent encumbered.
That's a political position.
Yeah, it was
political in general terms. Of course.
Exactly, policy decision. And it's also something that the governments are looking, you know, when they talk about open standards in the Spanish legal framework here, saying that all solutions provided to the Spanish government must be under open standards, and they have a much stricter incumbents-free definition of open standards, much better than the European Union. That, on the contrary, excludes players who want to use their patents as a commercial tool, which is perfectly in their right, of course. So sometimes what's bad about this is that you say, well, you want to play in my ballpark and you play in that ballpark. What we're trying to say here is no, we're all in the same ballpark, and we're trying to compete on qualitative service, on price, on efficiency. So patents are falsifying the game in that sense, and creating artificial barriers. Which I think is to the detriment of everybody in the end. Although I recognise that there are arguments on the other side of the fence, but more I think in the biotech and other industries where there may be more economic justification for this, as opposed to just using it as a legal tool in a competitive market.
Especially when there are fields where the return on investment is really delayed in time. So if you don't have a tool to monetize that, it's difficult. Not sure that patents, as they are presently, are the solution, but I see more the case for these fields. Whereas when you the results of your R&D are immediate and are in your software, putting patents is more an afterthought, more many times. So many companies come to me and say, oh, we don't believe really in patents. We need patents to defend ourselves against patent aggression. So we have a portfolio. And I accept, with a few exceptions, everybody's saying that they are amassing patents just in case, not for monetization, but to fence attacks from the external. So I think this is the wrong attitude. It should be, this threat should be removed to the benefit of everybody, with everybody agreeing that they shouldn't be used. So maybe this is double talk. This is not the real thinking, but if everybody was on the same table saying, okay, who's for patent, who's against? If you have a patent, would you delete the patent? I think that patent would not be touched. But this shows a sort of hypocrisy of this.
And also, I think on a wider scale. I mean,
not making an attack on anybody. I'm speaking of in general terms.
No. I mean, everybody's using
friendly companies say the same. That's.
Yeah. No, it also excludes innovative companies from markets like especially in the mobile sphere. I also think patents are territorial geographically, and I don't know any company that actually patents in any country of Africa or certain Latin American countries, for example, which is maybe an opportunity for people who want to avoid uncertainty of distributing in the American, which is the US market, because that's where patents are mainly held over certain of these things. So it gives a business opportunity for non-patented territories. The internet actually causes a problem with that, on the general thing, because if you're distributing via the internet, then it's very easy for a US court to say, hey, we have jurisdiction of that, especially if there's a platform, as everybody's online with their cloud service or whatever it is. So this service is available not just in Argentina where there are no patents, but also in Illinois where there are, because it's exactly the same service, the same place, and so the fact that again we're meeting up with this old debate, 20 something years ago, that the internet has no borders, but IP law does, and consumer protection law and privacy law and everything like that. So it's another ingredient in the debate. But I think this is something that anybody looking forward, thinking that there are 3 billion or more in non-patented territories of users and consumers, isn't that a market where actually there's money to be made, and they're not going to be making on the basis of patents.
Any more questions?
They're not just asleep, they're dead now.
Okay, comments?
I have a question for you. Can I ask a question?
Okay. I thought it was free.
And this is maybe a technical question with the guys in the room. This morning, Julian was differentiating his Ninja API guys, API ninjas, and his protocol gurus. And you've looked at this more than I have, I think. Is there a difference between, in legal terms, an API and a protocol? Is this just for the comfort of those who think that they're a guru rather than a ninja? I prefer to be a ninja because I have no patents on my APIs. But
I wonder why is Ninja one and a guru. Yeah, from a strict legal point of view, I see very little difference. So I would apply the same analysis to API as I apply to protocols. Maybe API are closer to the software than protocols are, or less separated from the software as the protocol. So in terms of the analysis of what you are legally allowed to do in order to reverse engineer or to discover secrets, or maybe it's more sensitive to go to find out what API are. Also because protocols or something that goes through the wire is clear. So you have one computer, another computer, a wire connecting. Anything that goes through that is at a protocol. When you speak about API, you have a more intimate, and the degree of separation are, in my poor understanding of technology, are lesser. So anytime you meddle with API, especially if they are not properly designed, you might end up with discovering internals, which can be sensitive and protective.
So the consequence of that is that if people are doing API licensing, or opening up an API, it means they need to be actually clearer at what they actually have to state, and the rights that they are granting, if they are granting rights, they have to be much better defined than if it's just the open specification of a protocol.
Yeah, we have in API we have a well-designed API, well-described API, and engineered API, and we have sort of less clearly defined, less clearly documented, less clearly separated, and this has consequences not only with the patent issue, but also in free and open source licensing, the interaction and the copyleft effect, or whether there is enough separation between two pieces of software to claim they are one software using another, or they are two pieces of the same software entity. I don't want to make another Microsoft example.
About to say we can leave that to the we can leave that to the courts. We can leave that to the courts of Hamburg for the moment.
I know there was an interesting discussion on a purely technical. At some point in a presentation by Microsoft in the antitrust litigation, there was a blue bubble, which means that there were places in the Microsoft network where servers were communicating so intimately, relying on knowledge of the internals of the algorithms between those servers, that they should have been regarded as one single piece of software running across physically separated software, but practically not being a separate entity, but one single entity on a logical basis. That was rejected. That was very, very well, but that shows that sometimes there is a blurred boundary between what's a protocol, a network protocol, an API, and what's simply an instance of the same thing scattered across different areas of memory, or even different computers.
That just makes life a little bit more complicated.
No complication, no lawyers, no business.
Yeah, exactly. Well, there's that too.
Eventually, I must disclaim that I'm making a good chunk of my living out of licensing patents. So I'm in clear conflict of interest speaking against software patents here.
We're in dichotomy. Okay.
So we're.
We on time?
Yes, we are 6 o'clock. We are 15 minutes ahead of time, but I think it's been a very long day, and I think we can.
They're all dying for a beer downstairs.
Okay. Doors are open if you want to escape.
Well, thank you very much.
Thank you.